Hi, I'm Joe Sorge, and welcome to the Family Law Report, where we examine the problems and challenges facing our family law system. This episode of the Family Law Report summarizes some recent research concerning parenting arrangements coming out of Sweden in 2014. The Scandinavians have been exceptionally progressive with respect to gender equality, especially concerning parenting responsibilities. For example, Swedish workers are entitled to 13 months of paid parental leave, up to $3,400 a month, and each parent must take at least 60 days of that leave or it is lost. Norway provides 4 months of paid parental leave just for the fathers, and if it is not used, it cannot be transferred to the mother. These incentives are intended to encourage men to participate in the rearing of children at an early age. Along these same lines, in separated or divorced families, shared parenting in separate homes is more common in Scandinavia than it is in the United States. When Scandinavian couples split up or divorce, custody battles are extremely rare. Parents living separately will often share parenting responsibilities without a fight. The prevalence of shared parenting has allowed Scandinavian researchers to study the developmental impact of shared parenting in two households versus primary custody in a dominant household. We believe that these studies are becoming more relevant to the United States as two-earner households are now the norm rather than the exception. In the first of 3 Swedish studies published in 2014, nearly 9,000 Swedish students aged 15 to 16 were surveyed for their willingness to turn to either parent for emotional support and for their subjective assessment of their health. About 60% of the students were living in intact households where both parents were still present. 18% of the students were living predominantly with one of their parents, similar to a primary custody arrangement in the United States, and another 18% of the students were living under a shared parenting arrangement that was relatively equal. The researchers found that both girls and boys were significantly less likely to confide in either parent when they were living under a primary custody arrangement. But when living in a shared parenting arrangement, they were as likely to confide in at least one of their parents as compared to children living in an intact family. Similarly, students were far more likely to confide in both of their parents when living in either a shared parenting arrangement or in an intact family. When these students were asked to assess their own health, the students who lived in a primary custody arrangement stated that they were significantly less healthy than students living in a shared parenting or intact family arrangement. In a second study, 164,000 Swedish students, ages 12 and 15 years old, were studied for different aspects of their well-being. 4 different living arrangements were studied: intact family, 50-50 shared custody, 30% or less time with one parent, or exclusively with one parent. In general, students from intact homes scored best. Students living exclusively with one parent scored worst. Students who lived in 2 households, but only up to 30% of the time with one of their parents, scored almost as poorly as students living exclusively with one parent. However, students living 50% of the time with each of their 2 parents scored far better than students living in imbalanced parenting arrangements. These differences were particularly apparent when students scored their physical health, their psychological well-being, their moods and emotions, and their relationship with their parents. Only when scoring access to material resources did students living up to 30% of the time with one of their parents rate their situation significantly better than students living exclusively with one parent. However, even though these students had more access to material resources than students living exclusively with one parent, their scores in the other well-being categories did not correlate with this increased access to material resources, and instead correlated with a reduction in physical time spent with one of their parents. A third relevant study coming from Sweden this year involved the question of whether children moving back and forth between 2 homes experienced more stress than children who reside with intact families. It's a common belief in the United States that alternating back and forth between 2 households causes stress in children. The research team approached the question in 2 ways. First, they asked the students whether they were experiencing recurrent pain, such as headache or stomach pains. They found no difference in the amount of recurrent pain amongst the 2 groups. Then they went a step further and measured the level of a stress hormone, cortisol, in the saliva of the students. Salivary cortisol was measured upon awakening, 30 and 60 minutes after awakening, and at 8 p.m. They found no difference in the levels of cortisol between the two groups. Both groups showed essentially the same normal daily rhythm for the stress hormone. These results are in conflict with the widely held belief that children who move between two households experience more stress than children who live in a single household. Shared parenting is a hotly debated issue in the United States. Proponents have pointed to statistics correlating the absence of one parent with increased social ills, such as drug addiction, alcoholism, teen pregnancy, truancy, depression, and other illnesses. However, opponents have argued that correlation does not necessarily mean causation, and that these social ills are more related to financial problems associated with single parenthood rather than to the lack of parental involvement. A recent study from the Pew Foundation contradicts that notion. The Pew study shows that men and women now end up about the same economically after divorce. Therefore, a child raised solely by a mother or a father after separation or divorce will have access to the same financial resources, whereas children raised equally by both parents will have access to both parents' resources. No matter how one looks at it, children are better off financially and emotionally when they spend substantial, meaningful time with both parents. It's time that Americans put an end to the incorrect myths related to primary custody. It's time that certain gender-based advocacy groups stop spreading falsehoods about children remaining in a single household. According to the laws of our land, we are not to discriminate based on gender, and the science now supports gender neutrality and equal shared parenting as being clearly in the best interests of the children. We frequently encounter comments on our Divorce Corp Facebook page favoring gender bias and primary custody arrangements. These comments typically come from three sources. The most brash come from practicing family law litigators who profit from custody battles. Their motives are transparent, and in light of the new science, should be taken with a grain of salt. We also receive comments from individuals who claim to be feminists, a term that used to mean women in favor of gender equality. But these individuals do not advocate equality, they advocate gender preference, pure and simple. We recommend to these advocates that they cease to forward a position that now, in light of the new data on equal shared parenting, amounts to nothing more than pure sexism. We also receive comments from victims of domestic violence who claim that equal shared parenting will expose children to abusers. This is certainly a legitimate concern and presents perhaps the greatest challenge to crafting beneficial parenting reform. We deplore domestic violence and abuse and would not want to see any legal reform increase the prevalence of these crimes against the defenseless. We must ask, though, if our existing system of laws and processes already contribute to an increased frequency of domestic violence. Non-abusive but emotionally volatile parents who are denied access to their children can become frustrated and at times desperate. Not being able to see one's children can make some parents feel unloved and unappreciated. Some of our Facebook followers have likened it to indentured servitude. We can see how these circumstances might lead to rising tensions and, in some instances, altercations that may not have occurred otherwise. We recognize that some causes of domestic violence are seated in mental and psychological disorders unrelated to our legal system. But we believe that a certain amount of domestic violence will end if we were to reform our laws to be in the best interests of the fractured family as a whole. Loving parents should not be branded potential abusers simply because of their gender. Punishing the majority to protect the minority is never the best answer. And in this case, not only do we punish the majority when awarding primary residential custody, we compromise the social and emotional development of the children as well. The time has come to deal with domestic violence like any other crime, in criminal court with appropriate criminal penalties. Family courts are ill-equipped to deal with these crimes. Criminal courts, on the other hand, are equipped with seasoned prosecutors and constitutional protections that our country has recognized is the best way we have for addressing criminal behavior. We need to move domestic violence accusations out of the family courts and instead respond accordingly when the criminal courts have spoken. It's time for meaningful reform of our family laws and family courts. If you would like to learn more, please visit our website at www.divorcecorp.com or attend our upcoming Family Law Reform Conference on November 15th and 16th outside of Washington, D.C. I'm Joe Sorge, and this is the Family Law Report. Thank you.